Um, no, I don't.
What is your defense to the allegations?
Um, I guess I I don't know. We just got an eviction notice, so I don't know. Maybe ask
Okay, Ashley,
ask
no,
Mrs. Washington.
Ashley Washington, no, sir. Ashley Washington, did you file any written response in this case?
I did attempt to reach out to the plaintiff to try to resolve the issue.
Ma'am,
Yes,
ma'am, the question is, did you file any written response in this case?
I don't believe so.
Okay, and what's your defense to the complaint in this case?
I'm not even 100% clear what the allegation is.
Mr. Close, you spoke to them this morning, correct?
I did
No.
not, Judge.
You did not.
I did not.
Marianne, would you move them into a breakout room for a second? Mr. Close, the court will do the contested hearings at the end of the docket.
Thank you.
Thank you. Good morning, Ms. Anna.
Good morning, Judge. How are you?
I am wonderful. How are you, ma'am?
I'm good.
Is there any occupant here?
I went into the wrong courtroom.
You went into the wrong courtroom, really?
I went into Judge Green's, and when I'm in there by myself, I figured I was in the wrong place.
You are. There are two. Let me get these two people in to see if, unless there's an occupant on the screen right now from 28560 Leroy Street. No. 28560 Leroy Street. Marianne.
Judge, can I find out who some of these people are? Do you mind?
Yes.
Is this a good time? The person who's identified as Darren Green, can you hear me?
Yes, I can hear you.
What case are you here for this morning?
Let me grab it.
All right.
He's
All right.
Marianne, he's 2232229.
Oh, I see Daryl Green. He says Darren Green. Okay. And the person who has the last name of Beavers, can you hear me?
Yes,
What case are you here for this morning?
I'm here for the Barrington case.
What's your, is it under Beavers?
It's under Taylor. I'm her roommate. I'm here on her behalf. It's Tykia Taylor.
Okay, I see that name. Okay. Thank you.
You're welcome.
To the woman with the purple shirt and the long dark hair, your name?
Michelle Cole.
Michelle Cole?
Yes, COLE.
Is that the name? Is that the name as it appears on the notice to appear this morning?
Yes, on the summons. I have a case number if that would help.
Ma'am, what type of case are you here for?
Landlord tenant.
That case number?
223274 LT.
Ms. Cole, your case has been dismissed.
Excellent. Is there anything
You're
else
free
that
to
I
go
need?
have a wonderful, no ma'am, you're free to go have a wonderful day.
Thank you very much. You too.
Thank you.
Mr. Bernkrandt, Miss Barrett is here. Do you need to go in a breakout room with her?
Oh, that's one of the cases I dismissed. I sent the dismissal in yesterday.
Oh, yeah.
I signed that dismissal in 223250 MIMG versus Barrett.
That is correct. I mean, I can explain it to her if she'd like, but
Oh, okay. I didn't know that. That's
No,
why I
ma'am,
was
Ms.
here.
Barrett, you're free to go. Thank you for logging on this morning.
Thank you. All right. Bye-bye.
There's someone who's joined us as a Zoom user. They are not identified. I've asked them repeatedly to turn their video on. Unless they turn their video on and identify themselves, I have to remove them.
You hear our conversation? No.
Sir,
Oh,
your
okay.
name, please?
You have to leave this.
who, me?
No, the gentleman in the car with the
Oh.
dreads or whatever that is. That's twisting your hair right now. I need your name, sir.
Oh, it's Lindsey Williams.
Oh,
Thank you, Mr. Williams.
David needs to move out. So the judge took 10 days to get out. She wants to know if, a little bit more time. I mean, yeah, I know, she's all. So. You want to give her?
Mr. Green, are you from Westlake Apartments?
Oh, I was muted. Yes, ma'am. I'm sorry.
That's okay. You're from Westlake Apartments and you checked in with us yesterday, a day early.
Yes.
Okay, no, I just want to make sure we have you correctly. You're identified a little differently on our docket sheet. This is 223114 LT. This is Epic Property Management versus any occupant at 28560 Leroy Street.
Good morning, Judge Carrie Zanin, P67390 on behalf of plaintiff.
Thank you. Is there anyone present that lives at 28560 Leroy Street in the city of Romulus? Today is the day and time set for the second hearing in this matter. First hearing was on July 13, 2022. Notice was sent to any occupant at 28560 Leroy Street to appear in person this morning at the courthouse at 9 o'clock. It's now 9:12 a.m. by the court's clock. No one has appeared in the courthouse claiming to have an interest in this matter. No one has responded to this court calling the case multiple times. Ms. Zanin, based on the fact that the defendant has failed to appear as directed by this court, how do you wish to proceed?
Plaintiff requests a default judgment with immediate possession. In our complaint, we did request immediate possession in paragraph 5F. So we're asking for a default judgment with the immediate possession. This is a squatter situation.
Understood, Ms. Zanin, and based on the fact that no one has presented themselves to present any defense in this matter, or any response to the request for immediate possession, the court will grant your request for entry default judgment with that provision. Ma'am, please email it to the court for entry. Anything else in this matter?
No, Your Honor.
Thank
will
you so
send that
much. You
over
have a
to-
wonderful day, ma'am.
Thank you, you too.
Thank you. Mr. Bernkrandt. This is 223253 LT. This is MIMG versus Brittany Clark and Jason Clark.
Yes, good morning, Your Honor.
Mr. Bernkrandt, today is the day and time set for the second hearing in this matter. The first hearing was on July 27, 2022, at which time the defendants failed to appear. Based on their failure to appear, the court clerk sent notice to them to appear in person this morning at the courthouse at 8:45 a.m. It is now 9:14 a.m. by the court's clock. There is no one here claiming to be interested in this property as far as the court is able to see. Do we have Brittany Clark or Jason Clark? Based on the defendant's failure to appear this morning, how do you wish to proceed, sir?
Your Honor, respectfully, we would like the entry of a default and default judgment.
The rent to retain possession is?
$1,225.87. The court costs I compute to be $176.
Thank you, sir. Based on the defendant's failure to appear as directed by this court, default judgment will enter in favor of plaintiff and against defendant with rent to retain of $1,225.87. There's $176 in court costs for a total judgment of $1,401.87. Plaintiff's office to submit that judgment. Anything else, Mr. Bernkrandt?
Nothing further on this matter, Your Honor, and thank you for your patience with me this morning. Thank you so
No
much.
worries, sir. I think that concludes your docket with us. Have a wonderful day.
Thank you. You too. Thanks.
Thank you. Janice Parker, Crystal Parker. This is 222803 LT. This is Janice Parker versus Crystal Parker.
Yes, this is Janice Parker.
Ma'am, turn your video on for me, please. Thank you. Crystal Parker. Today is the day and time set for the second hearing in this matter. The first hearing was on July 27, 2022, at which time the defendant failed to appear. Based on her failure to appear, court clerk sent notice to Miss Crystal Parker to appear in person this morning at 8:45. This case was scheduled at 9 a.m. It is now 9:16 a.m. by the court's clock. Defendant having failed to appear, Miss Janice Parker, how do you wish to proceed?
She's not showing up. She gave me the key to the house and she's just letting me have it. I don't think she's showing up today. I need to get into the home to fix the house up, ma'am. The pipes have been busted. I've been cited from here on township. It's just.
Ms. Parker,
Yes,
your request is to retake the property, correct?
correct, ma'am.
Ma'am, based on the defendant's failure to appear this morning, plaintiff is entitled to entry of default judgment, which will allow you to take the property in 10 days. Please
Okay.
contact the court to submit your judgment, okay?
Okay.
Anything else, Ms. Parker?
No, ma'am. So in 10 days, I gotta.
Ma'am, you need to file your judgment with the court first. You submit the judgment,
Okay.
which indicates that you are entitled to possession of the property and that the defendant has to move after 10 days. So the judgment will allow her 10 days to move. If she hasn't moved from the property or surrendered the property back to you in those 10 days, you can file a request for an order of eviction to have her physically removed from the property.
Okay.
Okay?
All right. So she's got 10 days. She don't do it, then I go back in front of, get a hold of 34th for the judgment.
Yes, ma'am, but
right?
first, you need to come file your judgment, or you can email it to the court, but contact the civil department if you have questions about how to do that.
Okay.
Okay?
Yes, ma'am. Thank you.
Thank you, ma'am. Have a good day. You're free to go.
You too. Bye-bye.
Thank you. Did Mr. Close come back out?
Yeah.
Yes, he's here.
Thank you. This is a recall of 223286 LT, Washington versus Washington and Washington. I already have your appearances. Mr. Close, you've now had an opportunity to speak to the defendants in this matter.
Yes, I have, Your Honor, and we've reached an agreement. My clients are going to consent to entry of a judgment of possession and vacate no later than September 1st, 2022. After that, a writ of eviction can issue if they haven't vacated.
Curtis Washington, you heard the comments made by Mr. Close just now,
Yes,
and it's your agreement to vacate the property on or before September 1st, 2022.
yes,
Miss Ashley Washington, you've heard the comments made by the attorney this morning,
Yes.
and it's your agreement to vacate the property on or before September 1st, 2022.
Yes.
Mr. Close, are you submitting a electronic version of this, or are you sending it around for signature to the defendants?
I'll submit an electronic version, Judge.
To the defendants, inasmuch as your landlord is represented by an attorney and you are not, the judgment that this court enters will not be final and enforceable for 3 days. Understood, Mr. Washington?
yes,
Understood, Ms. Washington?
Yes.
Anything else in this matter, Mr. Close?
No, Judge, thank you very much for your time.
Anything else, Curtis Washington?
that's it.
Anything else, Ashley Washington?
No.
We're all set. Everyone have a wonderful day. Thank you.
Thank you, Judge.
Have we seen Mr. Herman this morning?
Mr. Joseph is here for him and he's in a breakout room.
Thank you, ma'am. Mr. Graham Mason, do you have a case ready?
Yes, Your Honor. We can either take Ms. Cater or Ms. Johnson at this time if you would like.
We can do this one. 223205 LT Trilogy versus Angela Cater.
Hello,
State your name, ma'am.
Angela Cater.
Thank you. Today is the day and time set for the second hearing in this non-payment of rent case. Sir, you've had the opportunity to speak to Ms. Cater.
Yes, I have, Your Honor.
How are we
And-
proceeding this morning?
She has an ERAP number and case assigned, so we would request an adjournment based on a possible ability to pay in the future.
Ms. Cater, what is your ERAP number?
It is A202242.
And based on the fact that you have made an application for financial assistance, this court will stay these proceedings. The next thing is that you will receive a copy of that stay that indicates that if your landlord has not received payment or notification that you're ineligible for financial assistance within the next 45 days, they may file a request with the court to lift the stay and schedule these matters for additional proceedings. Understood?
Yes, ma'am.
Any questions, Ms. Cater?
No, ma'am.
Anything else in this matter on behalf of Trilogy?
No, Your Honor.
Ms. Cater, that concludes this matter, ma'am. You're free to go.
Thank you. Have a great day.
You too, thank you. This is 223204 LT. This is Trilogy Residences versus Patricia Johnson.
Corey Graham Mason appearing on behalf of Trilogy.
Ms. Johnson, state your name for the record, please, ma'am.
Patricia Johnson.
Thank you. Today is the day and time set for the second hearing in this matter. The parties have had an opportunity to speak. Mr. Graham Mason, how are we proceeding this morning?
We would request one final adjournment. Ms. Johnson appears to have some possible family help in this matter, and speaking to her and hearing her circumstances and how she's been gainfully employed and been an excellent tenant up to this point, like to give her a chance to resolve this prior to a final hearing on the matter.
This court's next landlord tenant date is September 7th, 2022 at 9 a.m. Anything else in this matter, Mr. Graham Mason?
Nothing further, Your Honor.
Anything else from you, Ms. Johnson?
No, and I apologize, Your Honor. Thank you for your time.
Why are you apologizing, ma'am?
Because I've come on hard times and this has never happened to me. And now I'm in this situation and it's just snowballing down. But I'm going to fix it.
Ms. Johnson, life happens, and
Yes,
Mr.
I
Graham
know.
Mason will be able to work something out with you, and if not, I'll see you here on September the 7th, back on Zoom,
Okay, thank
and
you,
we'll
Your
get it
Honor.
resolved, okay?
Thank
Have
you,
a
Your
good day,
Honor.
ma'am.
You too.
Thank you. To the woman with the braids that just joined us. Mr. Graham Mason, did you have any other cases ready?
Mr. Murph appears to have just gone into the waiting room, and I would like the opportunity to speak to him since he has appeared at the last second. But otherwise,
Mr. Graham Mason is not the last second. I'll let
Oh,
people
okay,
come
well-
until I get to the end of my docket. No, I start doing defaults at 9:15, but as long as you have people coming, go
right,
into your breakout room and we'll take care of them that way.
that sounds fine, Your Honor. Thank you.
Thank you. Mr. Katz. Where did Sydney go? Oh, there we are. Mr. Katz, did you have something ready?
I have two ready, and I did try bringing Taylor into the breakout room, but no one got pulled. It did, for whatever reason, didn't get pulled in.
It's her roommate, but if you wait, let's do the ones that are ready and then
Perfect.
we'll figure out what we're gonna do with your last one. So you're ready on 2232.
I'm sorry, I didn't know I was supposed to go into
No. What happens is when I call your name, you respond. If I'm doing something else, I need you to sit there quietly for me, please, okay?
Okay.
I'll see you in with Mr. Katz in just a moment.
Okay.
Thank you. This is 223275 LT. This is GI&I versus Lindy Williams.
Your Honor, I did not see Williams either. The two I have, well, actually, I have three. I have Christina Hodge, and I have
Okay.
Jerry Leon, and I have Elena Thomas. So Williams, I'm gonna have to pull in.
Let's do what you have ready. If it's Hodge, that's 223282 LT, GI&I versus Christina Hodge.
Good morning, Your Honor. Sidney Katz on behalf of the plaintiff.
Ms. Hodge,
Yes,
state your name for me, please.
Christina Hodge.
Thank you. Today is the day and time set for the second hearing in this matter. Both parties appeared back on July 27, 2022. Have had the opportunity to speak this morning. Mr. Katz, how are we proceeding in this matter?
Your Honor, I did speak with Ms. Hodge. She did apply for ERAP. I think the court is staying that. Is that correct?
We are. Ms. Hodge, what is your ERAP number, please?
C20152.
Ma'am, based on the fact that you've made an application for financial assistance, this court will stay the matter. The next thing that you will receive from the court is a copy of that stay that indicates that if your landlord has not received either payment in full within 45 days or notice that you're ineligible for financial assistance, they may make a request to the court to lift the stay and reschedule the matter for hearing, okay?
Okay.
Anything else in this matter, Mr. Katz?
No, not at this time.
Anything else, Ms. Hodge?
No,
Good luck to you, ma'am. Have a wonderful day.
thank you. You too.
Thank you. You were ready with Mr. Leon as well?
Sorry, Your Honor.
Mr. Katz, my question was, were you ready with Leon?
Yeah, can you give me 1 second? Just have to tell another court I need 5 minutes so I can finish up with
No,
you.
I'll pass all of your stuff. Go ahead with the other court, it's fine.
All right, thank you, Your Honor.
Mr. Green, did you speak to Mr. Joseph?
Yeah, yes, I did.
Have you filed for financial assistance?
Yes, I did.
I'm pulling him back here so we can get going. Now, Ms. Beavers, you should see an invitation to go into the breakout room. It'll be room number 8. When Mr. Katz is back, you'll go in there and speak to him, but you can go there now.
Okay, thank you.
Thank you.
The person who's identified as iPhone, can you hear me?
Yes, I can now. My signal was terrible. I'm so sorry.
What's your name, please?
Alana Thomas.
Okay, thank you.
I'm trying to get Joe Joseph and Curtis Brown out so we can get Mr. Green on his way. Mr. Graham Mason, were you ready with something?
Yes, Your Honor, I was able to speak to Mr. Murph, and I believe that we can call his case 3210 at this time.
Thank you. This is 223210 LT. This is Trilogy versus Daryl Murph. May I have your appearances, please?
Yes. Corey Grand Mason appearing on behalf of Trilogy.
Mr. Murph, thank you. Today is the day and time set for the second hearing. And this non-payment of rent case first hearing was on July 27, 2022. The parties have had the opportunity to speak. Mr. Graham Mason, how are we proceeding this morning?
It appears that Mr. Murph is in the process of applying for ERAP. He's one letter before getting his actual number at this point in time. I would like to afford him the opportunity to get that number and get those funds if he can. And if it's just the one stay, then so be it.
Thank you. Mr. Murph, this court's policy is once you've applied for financial assistance to stay these proceedings, the next thing you will receive is a copy of that stay from the court. It will indicate that within 45 days, if your landlord has not received payment in full or notification that you are ineligible for financial assistance, they may make a request for the court to lift the stay and schedule the matter for additional proceedings. Understood, sir?
Yes.
Mr. Murph, turn your video on for 1 second for me, please. Do you have any questions, sir?
No.
That's it. Have a good day. You're free to go.
Okay, thank you.
Mr. Graham Mason, was there something else?
At this point in time, we're just going to be seeking default entries against the remaining individuals on our docket.
Okay, give me 1 moment to get these other, did Mr. This is 223229 LT. This is Westlake Apartments versus Green.
Hey, good morning, Your Honor. Joe Joseph on behalf of the plaintiff.
Mr. Green, state your name for the record.
Darren Green.
Thank you. Today is the day and time set for the second hearing in this matter. Parties have had an opportunity to speak. Mr. Joseph, Mr. Green has advised this court that he's applied, excuse me, for financial assistance through the ERAP program. Is that accurate, sir?
Judge, we go into anything related to the ERAP program. We did work out a consent judgment, however, and I can put those terms on the record if the court wishes to proceed that way.
No, sir. Mr. Green, did I misunderstand what you said to me when you came out that you had applied for financial assistance?
Yes, I did. I applied for ERAP.
Your ERAP case number, sir.
The reference number is D19777.
Thank you. Mr. Joseph, this court's policy is once a tenant has made a request, an application for financial assistance, these cases are stayed. Mr. Green, the next thing you will receive from the court is a copy of that stay, which will indicate that no additional action will happen in this file right now. But if within 45 days your landlord has not received either payment in full or information to suggest that you're not eligible for financial assistance, they may make a request to lift the stay and schedule the matter for additional hearings. Understood?
Yeah. Judge,
If an additional hearing is necessary, at that time, the court would consider entry of the consent judgment. I'm sorry, Mr. Joseph, you were starting to say.
Yeah, I'm not really familiar with any law, administrative order, or anything that applies towards the ERAP program regarding a 45-day stay. Obviously, that seems to mirror a previous administrative order that applies to the SARA program. So I'm not really sure the authority for the court to do this beyond the scope of the parties' consent for an agreement to the contrary.
Mr. Joseph, you're objecting to Mr. Green having the opportunity to receive financial assistance so that he can keep his housing secure?
Judge, I am objecting to the court entering a 45-day stay without authority when the parties have worked out a consent agreement, and there's nothing that prevents the individuals and the corporation here, in this case Westlake Apartments and Mr. Green, for going beyond the scope of the consent judgment to allow for the financial assistance to work. But putting a stay on, again, I object based on the fact that there's no legal authority for the court to issue that stay.
Mr. Joseph, what would you like to do instead, sir?
Judge, I would request that the parties be allowed to move forward with the consent judgment that we've worked out. And then, as I mentioned to Mr. Green, he's free to continue working with the landlord to go beyond the scope of that agreement. But we already did extend it beyond the normal 10 days because he had indicated that he believes he'll have it all paid up by the 24th. So I gave him, and through our consent agreement, a consent judgment to the 24th to pay that.
To pay what, sir?
To pay the balance that is due and owing through today's date.
Would
And
you give me those numbers, please?
I can, Judge. Total rent to retain was $2,469, with cost being $164 for a judgment total of $2,633.
Mr. Green, you were able to hear Mr. Joseph just now?
Yes, ma'am.
And sir, that's what you wish to agree to?
I wish to have the 45-day stay to allow me more
We are
time.
not, sir. We are not, sir, because this court takes 2017, the administrative order to protect people who are seeking financial assistance through any of the funding programs. Mr. Joseph is accurate. And if it's his position, his client's position, that they don't want to allow the opportunity for the application to be processed, and they rather proceed with the consent judgment, this court will do that. I'm asking you, sir, is that what you wish to agree to this morning, that you owe a total of $2,469 in past due rent, $164 in court costs, for a total consent judgment of $2,633? Mr. Green?
I'm sorry, I wasn't sure what you were asking of me.
I'm asking, when you were in the breakout room with Mr. Joseph, did you agree to entry of a consent judgment in this case?
Yes.
You agreed that you had $2,469 in rent due,
Yes,
and you understood that plaintiff was seeking $164 in court costs.
yes,
You understand that that total judgment will be $2,633.
yes,
And Mr. Joseph has further advised that you have until August the 24th to pay that amount or move, sir.
yes,
And that is in fact what you wish to agree to.
no,
You said no?
yeah.
Why did you say no, sir?
Uh, as far as I know, I remember it. If I applied for the ERAP program, I haven't had any advisement in this case, so I'm not sure exactly of how it goes. So I wasn't sure what he was saying was the ERAP when we were in the breakout room, or because that's what I was advised to do in the lawyer that I spoke with before. So I wasn't sure.
Mr. Green, the lawyer advised you what, sir?
The lawyer advised me of the up until the 24th I would be able to. So I thought that was the ERAP, but I thought that was as far as I could go.
Mr. Green, I don't understand what you're saying.
I'm saying when I was in the breakout room, I thought that was the furthest that I would be able to stay and try to get the money up until that date.
You thought that August 24th was?
Yes.
And what changed between the breakout room and out here?
When I spoke to the previous attorney, she said that if I applied for the ERAP, it would be a longer day to be able to try to get the payments.
Mr. Green, the thing is that Mr. Joseph and I seem to have a different interpretation. There was an administrative order that spoke specifically to Sarah, the COVID emergency rental assistance program that will put stays in place. But because it specifically named Sarah and not later developed financial assistance programs, there are plaintiffs' attorneys, there are landlords' attorneys who do not wish that stay to apply. It is this court's policy and usual practice to put that stay in place. But Mr. Joseph is accurate, and once he objected to allowing more time for that ERAP application to process, this court cannot force him into it. So if you were in a breakout room with him and you agreed to a consent judgment, this court will enter it. If you're disputing the amount of rent that is due and owing, that is a different conversation for a different day.
Oh,
So
no, I'm
Mr.
not
Green,
disputing.
You're not disputing it?
No, I'm not disputing the amount.
Okay. Mr. Green, when you don't dispute the amount, there is not a triable issue. So Mr. Joseph is free to enter into an agreement with you, and that's what the parties appear to have done, enter into a consent judgment with the terms that I have now placed on the record. Mr. Joseph, how did you intend to get the signatures on the consent judgment, sir?
Judge, before I had advised the defendant to come back into the virtual courtroom, he had given me his consent to sign his name to a judgment that reflects our agreement. I'm happy to do so and submit that to the court.
Mr. Green, did you give Mr. Joseph authority to sign that consent judgment on your behalf?
Yes.
Sir, inasmuch as your landlord is represented by an attorney and you are not, the judgment will not become final and enforceable for 3 days. Mr. Joseph will send it to the court electronically. I will review it and sign it so long as it has the same terms that we've just placed on the record. Okay, sir?
All right.
Anything else, Mr. Joseph, in this particular matter?
Nothing further, Judge. Thank you.
Anything else, Mr. Green?
Nope.
Mr. Green, we're all set, sir. You have a wonderful day. Thank you.
Thank you.
This is 223231 LT. This is Southport Apartments versus Curtis Brown. May I have your appearances, please?
Thank you, Judge. Joe Joseph on behalf of the plaintiff.
Mr. Brown, state your name for me, sir.
Curtis Thomas Brown, Jr.
Thank you, Mr. Brown. Today is the day and time set for the second hearing in this non-payment of rent case. The parties have had an opportunity to speak. Mr. Joseph, how are we proceeding this morning?
Thank you, Judge. There is not a consent judgment on this one. Mr. Brown did indicate that similar to the last individual he filed for ERAP. obviously know what the court's policy is. We would object to a 45-day stay. I'll leave it at the court's discretion on what it would like to do in terms of moving forward. But that's where we're at, Judge.
You're
And
not
it-
leaving it to the court's discretion, Mr. Joseph. You made a pretty good record in the last case. Mr. Brown,
Yes,
you made an application for ERAP financial assistance.
yes, ma'am.
Mr. Joseph, how much rent is due and owing?
Thank you, Judge. There's a total amount of $3,895 that's due and owing, and costs are $164. So the total amount is $4,059.
Mr. Brown, do you admit that $3,895 in rent is due and owing?
Yes, ma'am.
Mr. Brown, inasmuch as you admit that that is the amount of rent that is due and owing, there is not a tribal issue of fact in this case. The court
Ma'am,
is prepared to enter judgment in the amount requested by plaintiff, that being $4,059, which is inclusive of $164 in court costs.
Your Honor,
Sir,
about a week ago, I received paperwork stating that I owed $1,280 in rent. I'm sorry, $1,600 in rent. I was prepared to pay that. And then I was told that I owed 2 months rent. And that was just last week. And as of last week, I applied, well, on May 20th, I applied for Sarah and hadn't heard anything back. And then as of last week, I applied for the Wayne County Rental Assistance Program and haven't heard anything back from them. Yes?
I need you to stop moving around for me, please, sir. You
Oh,
said
okay.
you applied for Sarah?
Yes, on May 20th.
And what happened with that Sarah application, sir?
I haven't heard anything back as of yet, ma'am.
Do you have a
So-
Sarah reference number?
Yes, I do.
What is that Sarah reference number, Mr. Brown?
It's C16334.
That's not a Sarah number, sir.
That's the number on the letter they sent me, ma'am, and the letter that they emailed me. And then Wayne County Rental Assistance also sent me a different number, and it is C20002.
Judge,
And I'm sorry, Mr. Brown, that first number, the C16334, you said was a Sarah number from which agency?
1 second.
Mr. Joseph, do you have any information about a Sarah application for Mr. Brown?
no, I don't. I believe both of those, Judge, are ERAP numbers.
They are, Mr. Brown. They are ERAP numbers.
Oh, okay. Well, yeah, the letter does look the same for both places.
Okay, Mr. Brown, where we are right now is I asked you, did you agree with the amount of rent that's due and owing? And you said yes. And then when I get prepared to enter the judgment in this case, you say that you received paperwork that there's a different number that's due and owing for rent.
Right,
So
I don't
which one of those-
have. Yes,
He's right, Judge, only insofar as I'm just making this assumption. The paperwork he's referring to would have been the lawsuit that was issued in June, which would have given his then balance, which would have been right around $1,260, $1,280, something in that neighborhood. I don't have the complaint in front of me, but I'm sure it's in the court's file. But since that time, July's rolled through without a payment, and now August has rolled through without a payment. So that balance has increased to where it is right now.
excuse me, there was a payment made of $2,600 since that time.
No, that payment,
Okay, no. This court is not doing contested matters this morning, right now. Mr. Brown,
Yes,
my question to you is, do you owe $3,895 in rent?
yes.
Mr. Joseph, if you would submit a judgment that shows $3,895 in rent, $164 in court costs, the court will enter it.
thank you, Judge. And I would,
Anything else in this matter, Mr. Joseph?
yeah, I just want Mr. Brown to understand that there was a payment of the $2,600 that he referenced, and that was applied on May 31st. So that was actually applied to this.
So that being applied to this, there's still an
No,
outstanding
listen,
balance?
no. I'm gonna move you all back into the breakout room. I'll recall this case. Mr. Katz.
Good morning, Your Honor. Let me shut the volume down there.
Were you ready with something, Mr. Katz?
Yeah, I've got two that I am ready on and two people I've tried to pull into the breakout room that I was unable to. So if we can call, I've got Jerry Leon, I have Lindsay Williams, and I did think I had someone else, but let's start with those. Oh, and I also had Elena Thomas. That's the third one.
This is 223275 LT GI&I versus Lindy Williams.
Good morning, Your Honor. Sidney Katz on behalf of the plaintiff.
Lindy Williams,
Yes.
turn your video on and state your name for the record, please.
My name is Lindsay Williams.
Thank you. Today is the day and time set for the second hearing in this matter. Parties have had an opportunity to speak this morning. Mr. Katz, how are we proceeding?
Your Honor, I did discuss this matter with Mr. Williams. We did enter in a consent judgment. He understands he's got a balance due as of today of $4,164. He has until August 15th to pay that amount, and he was advised of MCR 4.201 and did authorize me to submit this to the court with his verbal authority, Your Honor.
The $4,164 is what rent and what cost?
Oh, I'm sorry, $3,999 of past due rent, $165 of cost for a total of $4,164.
Mr. Williams, you were able to hear Mr. Katz just now?
Yes.
Sir, do you agree that $3,999 in rent is due and owing in this matter?
Yes.
And that plaintiff is requesting $165 in court costs? Mr. Williams, have you made an application for financial assistance through any program?
No.
And you've authorized Mr. Katz to sign your name to the consent judgment?
Yes.
And Mr. Katz further advised you that because the apartment is represented and you are not, your judgment will not become final and enforceable for 3 days.
You said what?
Because your apartment complex is represented by an attorney and you are unrepresented, your consent judgment will not become final and enforceable for 3 days.
Okay.
Mr. Katz, please submit that consent judgment for entry. Mr. Williams, you are free to go. Have a good day.
Thank you, Your Honor.
Thank you. And you spoke to, did you ever go in with the representative for Ms. Taylor, Ms. Beavers?
I did not. I do need to get Taylor and McNeil into my breakout room. I tried to invite them in, but for some reason, sometimes it just doesn't pull people in. But I do have two
Ma'am.
consents.
Yep, Mary Ann will send an invite for you to do that again. And while you're gone, I'll take Mr. Graham Mason's cases.
Okay.
This is 223196 LT. This is Trilogy versus Meredith Buzzio. Today is the day and time set for the second hearing in this matter. The first hearing was back on July 27, 2022, at which time the defendant failed to appear. Based on that failure to appear, the court clerk sent notice to the defendant to appear in person today at 9 o'clock. It's now 9:53 a.m. by the court's clock. Defendant has failed to appear. Mr. Graham Mason, how are we proceeding? You're muted.
I apologize, Your Honor. We're seeking a default judgment at this time for possession.
Rent to retain possession, sir.
$4,788.90.
Cost,
$164.57 for a total of $49.53.47.
inasmuch as defendant has failed to appear as directed by this court, default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession of $4,788.90, $164.57 in court costs for a total judgment of $4,953.47. Plaintiff's office to submit that judgment for entry. This is 223197 LT. This is Trilogy versus Latanja Dotson. Today is the day and time set for the second hearing in this matter. First hearing was on July 27, 2022, which time the defendant failed to appear. Based on that failure to appear, court clerk sent notice for the defendant to appear in person at 9 o'clock. It's now 9:55 a.m. by this court's clock. Defendant having failed to appear. Mr. Graham Mason, how do you wish to proceed?
We would like to proceed seeking a default possession judgment.
Rent to
The
retain,
is $4268.99. Costs in this matter are $164.57 for a total of $4,433.56.
defendant having failed to appear as directed by this court, default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession, $4,268.99, for a cost of $164.57 for a total judgment of $4,433.56. Plaintiff's office to submit that judgment for entry. This is 223202 LT. This is Trilogy Residences versus Alexander Fowler. Today is the day and time set for the second hearing on this matter. First hearing was on July 27th, at which time the defendant failed to appear. Based on the defendant's failure to appear, court clerks sent notice to the defendant to appear in person this morning for hearing. The defendant has failed to appear. The case was scheduled at 9 o'clock. It is now 9:56 a.m. by this court's clock. Mr. Graham Mason, how do you wish to proceed?
At this time, Trilogy would seek a default possession judgment. The right to retain or rent to retain possession in this matter is $3,537.04. Costs in this matter are $164.57 for a total of $3,701.61.
Defendant having failed to appear, default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession, $3,537.04, $164.57 in court costs, for a total judgment of $3,701.61. Plaintiff's office to submit that judgment for entry. This is 223214 LT. This is Trilogy versus Hope Priest. Today is the day and time set for the second hearing in this matter. First hearing was on July 27, 2022, at which point the defendant failed to appear. Based on the defendant's failure to appear, court clerks sent notice to the defendant to appear in person this morning at 9 a.m. It is now 9:57 a.m. by the court's clock. Defendant has failed to appear. Mr. Grant Mason, how do you wish to proceed?
In this matter, we would also seek a default possession judgment. The rent to retain possession in this matter is $3,450.01. The costs incurred are $164.57 for a grand total of $3,614.58.
Based on the defendant's failure to appear this morning, default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession, $3,450.01, court cost of $164.57 for a total judgment of $3,614.58. Plaintiff's office to submit that judgment for entry. This is 223215 LT. This is Trilogy Residences versus Sheila Reynolds. Today is the day and time set for the second hearing in this matter. First hearing was July 27, 2022, which time the defendant failed to appear. Based on the defendant's failure to appear, court staff sent notice to the defendant to appear in person this morning. Defendant was supposed to be here at 9 o'clock. It is now 9:58 a.m. by the court's clock. Defendant has failed to appear. Mr. Graham Mason, how do you wish to proceed?
We wish to proceed with a default possession judgment at this time.
Rent to retain possession is?
Rent to retain possession in this matter is $3,920.81. Costs incurred in this matter, $164.57, for a grand total of $4,085.38.
Based on the defendant's failure to appear as directed by the court this morning, default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession of $3,920.81. There's $164.57 in court costs for a total judgment of $4,085.38. Plaintiff's office to submit that judgment for entry. This is 223222 LT. This is Trilogy versus Angelo Pearl and Melissa Pearl. Today is the day and time set for the second hearing in this matter. First hearing was on July 27, 2022, at which time the defendants failed to appear. Based on their failure to appear, court staff sent notice to the defendants to appear in person this morning at 9 o'clock. It is now 10 a.m. by the court's clocks. Defendants having failed to appear. Mr. Graham Mason, how do you wish to proceed in this matter?
We wish to proceed for a default possession judgment in this matter. The rent to retain possession is $4,072.60. Costs in this matter are $199.14 for a grand total of $4,271.74.
Based on the defendant's failure to appear as directed by this court, default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession of $4,271.74. Rent to retain possession of $4,072.60. Court cost of $199.14 for a total judgment of $4,271.74. Plaintiff's office to submit that judgment for entry. Mr. Joseph. This is
Yes, Judge.
223233 LT. This is Southport Apartments versus Stephen Jemison and Michael Jemison.
Thank you, Judge. Joe Joseph on behalf of the plaintiff.
Today is the day and time set for the second hearing in this matter. First hearing was on July 27, 2022, at which time the defendants failed to appear. Based on their failure to appear, court staff sent notice for them to appear in person this morning at 9 a.m. It is now 10:01 a.m. by this court's clock. Stephen Jemison, Michael Jemison. Based on the defendant's failure to appear this morning, Mr. Joseph, how do you wish to proceed?
We wish the court to enter a default judgment of possession for a total rent retain of $3,570. Cost are $198, total amount $3,768 with a writ to issue after the 15th of August.
Defendants having failed to appear as directed by this court, default judgment shall enter in favor of plaintiff and against defendants with rent to retain possession of $3,570, court cost of $198 for a total judgment of $3,768. Plaintiff's office to submit that judgment for entry. This is a recall of 223231 LT. This was Southport versus Curtis Brown. I'd ask that you go back into the breakout room. There seemed to be a question about the balance in this matter. I don't know, did you all actually go, or was there a genuine question about the balance that's due and owing in this matter?
We weren't able to, I could go back in, but I don't think he was able to, and I couldn't pull him in. I'm not listed as a co-host or anything. So, but I don't think there's, I don't think there's an issue, Judge. I'm not sure where we stand. I know the court had previously issued the judgment and then wanted us to go back for any clarification.
No, well, because Mr. Brown, I asked a couple of times about the balance, and he agreed that there was $3,895 due. And then Mr. Brown said, no, there is a payment of $2,600. Your indication to this court was that that payment was made and posted back in May, which would have predated the filing of this complaint by almost 2 months, I believe.
That's
so, Mr.
correct.
Brown, the question to you is there $3,895 due in rent?
No, ma'am, I don't believe so. I believe I owe for, apparently I owe for June and July because August just got here. August is only 3 days old. And last week, my paperwork stated, the most recent paperwork that I got on this case stated that I owed $1,280 or something like that, $1,600. I know I had the money to pay it. And I was told that, that I needed to, that I was going to be in court anyway, and the balance was substantially more than what my paperwork showed.
Mr. Brown,
Yes.
the court has a copy of the complaint from June the 21st that lists that you owe $1,280.
And that's the last paperwork that I got.
And then, sir, July would have come due, which is another $1,270, which takes us up to 2,500-ish. And then
Yeah.
August came due on August 1st, which takes us to 3,000 and some odd. My math is, I don't have the calculator. So, Mr. Brown, I'm just trying to follow your logic.
Well, okay. Apparently my logic is off, but God, my biggest problem is that my paydays don't line up in time. But anyway.
I'm sorry, your biggest problem is what, sir?
I actually work for the company where I live, and my paydays don't line up in time for me to pay my rent on time. And honestly, I have as of this Friday, which is payday, I'll have the 2,000 whatever, and then 2 weeks following, I would have the money to make up the August rent.
Judge, I'm happy to give Mr. Brown additional time to make those payment dates align. So if the court did enter a judgment, I would be agreeable to extending the writ date out to the to the 19th, I believe, is because if he gets paid this Friday, which is the 5th, and then the 19th, so we can essentially give him until we'll make the writ date no earlier than the 22nd.
Mr. Brown, were you able to hear and understand what Mr. Joseph just said on the record?
Yes, ma'am.
It'll have a pay or move date of August the 19th, 2022. Mr. Joseph, you would submit that, that judgment electronically to the court for entry. I'd be most appreciative.
Yes, Judge, we'll get that to the court this afternoon.
Anything else, Mr. Brown?
No, ma'am.
Sir, you have a wonderful day. Thank you for your patience with the court this morning.
Thank you. You have a good day too, ma'am.
Thank you. Anything else, Mr. Joseph?
Nothing further, Judge. Have a great morning.
You too. Thank you.
Thank you.
This is 223257 LT. This is Pinewood Circle versus Elena Thomas.
Good
Yes.
morning, Your Honor. Sidney
Good morning.
Katz on behalf of the plaintiff.
Ms. Thomas?
Alana Thomas, sorry.
Thank you. Today is the day and time set for the second hearing in this matter. The parties have had an opportunity to speak.
Yes, Your Honor. We did enter into consent judgment, if I could put the terms on the record.
Absolutely.
Your Honor, there is currently a balance due of $3,180, $81 of past due rent, $165 of costs for a total of $3,000.
Wait. I'm sorry, Mr. Katz. Start again for me.
3,181 of rent, costs of $165 for a total of $3,346. Ms. Thomas has until August 17th to pay that amount, and she was advised of MCR 4.201 and did authorize me to submit this to the court with her verbal authority.
Ms. Thomas, you were able to hear Mr. Katz just now?
Yes, I was.
And ma'am, you agree that there's $3,181 in rent due and owing?
Yes.
And that
Well,
plaintiff
some
is
of it has
requesting
been
$165 in costs
Yes,
for a total amount of $3,346?
yes,
And you've authorized Mr. Katz to sign your name to a consent judgment?
yes.
And you understand that because Mr. Katz represents your landlord, you do not have an attorney this morning, that judgment will not be final and enforceable for 3 days.
Yes, ma'am.
Anything else, and anything else in this matter, Mr. Katz?
No, I think we're good. Thank you, Your Honor.
Anything else, Ms. Thomas?
Yes, could I get that exact amount one more time? Because I have to go up to the office and make sure that they subtract what I already put in there. So
Could
I get that?
$3,346.
Okay, thank you.
What do you mean what you just put in there?
Oh, no, I made a payment yesterday. He just hasn't got it yet. It's okay. I can go up
Okay.
to the office and actually talk to my rental apartment. It's okay.
Thank you, ma'am.
Thank
Have a good
you.
day.
Have a great one.
You too. This is 223276LT GINI versus Taylor.
Good morning, Your Honor. Sidney Katz on behalf of the plaintiff.
I'm here.
State your name, please.
Miasia Beavers.
Your Honor, I did have an opportunity to speak with Ms. Beavers. She is a party on the lease, according to her. This case was filed against all other occupants. I did indicate that I could add Ms. Beavers to the caption of the case, but we did enter into an agreement giving the parties until August 22nd. So I did indicate that it would not make a difference if I did include a consent, because I'm going to have to get a default regardless against Keisha Taylor. So at this point, I'm just going to enter this as a default judgment, Your Honor, unless Ms. Beaver indicates otherwise. But
Ms. Beavers, my question to you is, where's Ms. Taylor?
She's been sick. She's been sick lately in the hospital. So I had to take over the lease because she had to move back in with her parents because she's been sick and haven't been able to handle it. So I will be paying the remainder of the rent, and I will have it before I will have it August 22nd. She got sick, been in and out the hospital since. Just been handling everything on my own. And she moved out.
Appreciate your effort. Mr. Katz, Ms. Beavers is listed on the demand for possession, but not listed on the summons and complaint. I'll take her as all other occupants.
Perfect.
So if you want to do it by default, that's fine.
I think it benefits Ms. Beavers by doing it that way, since nothing changes on the caption, on the amount of time given, Your Honor. So if I could put
And the
that on
rent
the
to
record.
retain possession is?
$2,327 of past due rent, $165 of cost, for a total of $2,492. The parties have until August 22nd to pay that amount.
Ms. Beavers, were you able to hear and understand what Mr. Cash just placed on the record?
Yes, ma'am.
Okay, you'll get a copy of the judgment in the mail in the next few days. Good luck to you and good luck to Ms. Taylor.
All right, thank you.
Thank you. Ms. McNeil. This is 223283LT. This is GINI versus McNeil. May I have your appearances, please?
Good morning, Your Honor. Sidney Katz on behalf of the plaintiff.
Hi, my name is Detara McNeil.
Thank you. Today is the day and time set for the second hearing in this case. Mr. Katz, you've had an opportunity to speak. How are we proceeding this morning?
Your Honor, we did discuss this matter. We did enter a consent judgment. Your Honor, if I could put the terms on the record. This is a non-payment rent possession judgment case. Currently, there is a balance due of $3,938 of past due rent, $165 of costs, for a total of $4,103. We did agree to give until August 22nd for that amount to be paid. And
I'm sorry, 22 or 27?
22, I'm sorry. I'm stuttering my words today, Your Honor. August 22nd. And she was advised of MCR 4.201 and did authorize me to submit this to the court with her verbal authority.
Ms. McNeil, you were able to hear Mr. Katz just now?
Yes,
And it's your agreement that you owe $3,938 in rent?
yes,
And you understand that the plaintiff is asking for $165 in court costs,
yes,
which has a total judgment amount of $4,103.
yes,
And ma'am, that's what you wish to agree to?
yes, ma'am.
And you've authorized Mr. Cass to sign your name to that consent judgment.
Yes, ma'am.
And he explained that because the apartment complex is represented and you are not, that judgment is not final and enforceable for 3 days.
Okay.
Ma'am, inasmuch as that is your agreement, Mr. Katz will sign your name to that consent judgment submitted to the court for entry. You'll get a copy in a few days. Anything else, Mr. Katz, in this matter?
No, Your Honor.
Anything else, Ms. McNeil?
No.
Ma'am, thank you for your extreme patience this morning. You have a wonderful day. Thank you.
You too. Thank you.
Did we lose Mr. Graham Mason?
I do have one more, Your Honor, Jerry Leon.
Yeah, oh, nope. 2232580 LT. This is Pinewood Circle versus Leon.
Good morning, Your Honor. Sidney Katz on behalf of the plaintiff.
Unmute yourself, please, and state your name for me.
I'm sorry, I thought I was on mute. Jerry Leon.
I am so sorry. When I called the case before, I saw you pop on. And then I lost track of you. I'm laughing about something completely unrelated. It's fine. Today is the day and time set for the second hearing in this matter. The court did receive notice that after the July 27th hearing, the defendant reached out to the court because the hearing date they got the wrong hearing date or got the hearing date wrong. In any event, yes. Mr. Katz, you've had an opportunity to speak to the defendant this morning. How are we proceeding?
Your Honor, we did enter a consent judgment at this time. Currently, there's a balance due of $4,064 of past due rent, $165 of costs for a total of $4,229. Defendant has until August 15th to pay that amount and was advised of MCR 4.201 and did authorize me to submit this to the court with her verbal authority.
Ma'am, you were able to hear Mr. Katz just now?
Yes.
And it's your understanding and agreement that $4,064 in rent is owing at this time?
Yes.
And that plaintiff is requesting $165 in court costs?
Yes.
For a total judgment of $4,229?
Yes.
And you've authorized Mr. Katz to sign your name to that agreement?
Yes.
And you understand that because your landlord is represented by an attorney and you are unrepresented, that judgment will not be final and enforceable for 3 days?
Yes.
Thank you. We are all set. You have a wonderful day. You are free to go.
You as well.
Thank you.
Mr. Katz, I have 4 more cases with you. 223268 LT. This is Pinewood Circle versus Jalen Bell.
Good morning, Your Honor. Sidney Katz. Oh, sorry.
I'm sorry.
Jump the gun.
Today is the day and time set for the second hearing in this matter. First hearing was on July 27, 2022. The court rescheduled, set the second hearing in this matter for today at 9 o'clock. It's now 10:17 by this court's clock. Jalen Bell. There are no unidentified persons in the courtroom. No one appearing on this matter on behalf of the defendant. Based on the defendant's failure to appear this morning, Mr. Katz, how do you wish to proceed?
Your Honor, at this time, requesting a default judgment. I did receive a phone call from a family member who claimed to be an attorney. They never put an appearance on the record. They told me before the first hearing that they were going to have the amount paid, but obviously that didn't happen. So at this point, Your Honor, requesting a default judgment. There's currently a balance due of $4,336 of past due rent, $165 of costs for a total of $4,501. Requesting a default judgment in that amount with a writ to be issued after August 15th.
Thank you, sir. And as much as the defendant failed to appear as directed by this court, default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession, $4,336, $165 in court costs for a total judgment of $4,501. Plaintiff's office to submit that judgment for entry. This is 223271 LT. This is GI&I versus Shane Lee. Today is the day and time set for the second hearing in this matter. Mr. Katz, the court notes your appearance for the record. The case was scheduled at 9 o'clock. It's now 10:18 by the court's clock. Defendant has failed to appear, sir. How do you wish to proceed?
Your Honor, at this time requesting a default judgment. This is a non-payment rent possession judgment case. Currently, there's a balance due of $2,703 of past due rent, $165 of costs for a total of $2,868. Requesting a default judgment in that amount with the writ to be issued after August the 15th.
Defendant having failed to appear as directed by this court, default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession, $3,702, $165 in court costs for a total judgment of $2,868. Plaintiff's office to submit that judgment for entry. This is 223273 LT. This is GI&I versus Raphael Leeper. Today is the day and time set for the second hearing in this matter. Mr. Katz, the court notes your appearance for the record. This matter is scheduled for hearing at 9 o'clock. It's now 10:19 by the court's clock. Defendant has failed to appear. Mr. Katz, how do you wish to proceed?
Your Honor, at this point, requesting a default judgment. This is a non-payment rent possession judgment case. Currently, there's a balance due of $2,039 of past due rent, $165 of costs for a total of $2,204. Requesting a default judgment in that amount with the writ to be issued after August the 15th.
Defendant having failed to appear as directed by this court, default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession of $2,039, $165 in court costs. Total judgment of $2,204. Plaintiff's office to submit that judgment for entry. This is 223281 LT. This is GI&I versus Kelani Haddon. Today is the day and time set for the second hearing in this matter. First hearing was on July 27, 2022. This second hearing was scheduled at 9 o'clock. It's now 10:20 a.m. by this court's clock. Defendant having failed to appear. Mr. Katz, how do you wish to proceed?
Your Honor, this matter was, I think I sent it twice to the court already as a dismissal. Because after we were at mediation last week, I indicated it was dismissed. They said it was not on the record. I think I then sent it again, which is odd, because that usually does not happen.
The court's
So it
made
is
a
a dismiss-
notation in the file that the matter is going to be dismissed.
Thank you, Your Honor.
I think that concludes the court's docket. Mr. Katz, can I speak to you on a completely unrelated matter, please?
Yes, Your Honor. I
Thank
did
you.
respond to your chat, by the way.
You did, sir. Mary